import of maize and withdrawing the restriction of actual user. In view of the discussion above, the impugn notice is held to be issued by DGFT but to implement the decision of the Government of India and merely a clarificatory in nature and conformity to the public notice of similar nature issued every year from 2003 onwards. So and so itself. In view of the discussion above, particularly extent of quota allotted under TRQ, the actual import as discussion of para 13 above, it cannot be said that the policy of the Government of India with regard to import and export on facts in present case is justiciable, and even otherwise the said policy cannot be said to be arbitrary against public interest. Lord, therefore, kindly see, Lord, that in this paragraph 24, the learned judge said, I have drawn the table. So these are the factual basis. In writ appeal, these facts are not disputed. They could have said, my lord, that any of the grounds that the facts extracted by the learned single judge, these tables given with regard to the percentage of import qua the export, or my lord, the exact actual amount of import, all this is given as facts and it has no impact. So what is the public interest? According to them, the public interest is that by virtue of your import, there is an imbalance in the domestic market. So that should be based on fact. Even if it is there, my lord, I still have some argument, but that factual basis alone is not there. Even writ appeal, they could not improve. So it's a matter of, my lord, almost an honest factum of, my lord, not proving the case on facts. We'll go to the law, my lord, at later stage, but factual basis that by virtue of this import, this market, these people, these agriculturists, how much maize is grown here, no particulars, nothing. So, my lord, my submission is, it is the policy supported by statute, it has got certain application of mind, and my lord, that has been, my lord, been there for some time. There are certain modifications. That alone is being challenged now. The power, my lord, is there under the Act, there is no doubt about it. But the conditions which are relaxed now, these being challenged. If it is relaxed, what is the public interest suffer? The only argument is public interest. And public interest, no factual basis. So this is, my lord, that's why my submission is the learned single judge considered everything on facts. My lord, facts and law, all aspects, my lord, has been considered. And how the learned single judge judgment is wrong has not been pointed out. Lordships have said, my lord, several times under clause 15, be it a writ appeal or, my lord, on the civil side. Now we are not on the civil side, but the writ appeal court in these matters will have look at the correctness of the learned judge. My lord, as Wade puts it, in judicial review and appeal, the distinction is judicial review looks at the process, the authority comes to the conclusion, only not on merits of the case. In appeal, the right or wrong of the order is tested. So therefore, in writ appeal, like any other appeal, the right or wrong of the learned single judge has to be tested. What is wrong with the learned single judge's order? Well, I have gone through the appeal grounds. Appeal grounds also do not make out any legal contentions. And, my lord, fortunately, there is further improvement on what has happened before learned single judge. I submitted lordships, the apex court judgment, which clarifies that DGFT is entitled to give such clarification and amendment, and also that notifications again issued by central government. So that ground goes all together. And the grounds, my lord, Lordship can see. I'll just, my lord, make my final submissions on the grounds. Lord, shall I continue?
How long will you take?
I will not take more than half an hour, my lord, in this matter. Less than half.
When can we have this? Tomorrow is not possible.
Yes, sir.
Tomorrow is not possible.
Lord, you lordship have it on 5th. Unfortunately, Lord, next week, entire week, I have some serious old arbitrations going on, my lord. Except 5th, if lordship accommodate me, my lord, on 5th.
5th. arguments of Mr. Rishi Raghuram. It is entirely up to, we are now dealing with writ appeal.
Including the
Let
next
us,
batch of.
keep our focus intact. Let us not go here and there.
Subject to my lord's permission, my lord, I am the petitioner in item 66 in this batch, my lord.
Exactly.
Earlier there was an order allowing councils to appear.